Hi folks, it's 6:30, and we usually like to try to get started at this time. I'd like to thank everybody for showing up at the McGregor Downs here on June 10th, and it's 6:30, and we are about ready to hear North Carolina Supreme Court Justice Philip Berger speak on life, liberty, and the fruits of your own labor, which is, I think it's a pretty exciting topic, and it fits in right in with the Basquiat Society. And in fact, Professor Salzman of Duke University is going to now introduce more about Justice Berger, and I think he might even talk about Basquiat, which is pretty relevant. So, great. Thank you.
Thank you. Welcome, everyone. Thank you. Our namesake, Frederick Basquiat, said, "The law is the organization of the natural right of lawful defense. It's the substitution of a common force for individual forces. And this common force is to do only what the individual forces have a natural and lawful right to do. To protect persons, liberties, and properties, to maintain the right of each, and to cause justice to reign over all. When a portion of wealth is transferred from the person who owns it without his consent and without compensation, whether by force or by fraud, to anyone who does not own it, then property is violated. An act of plunder is committed." And this is exactly what the law is supposed to suppress. When the law itself commits this act that is supposed to suppress, plunder is committed. That's Basquiat. I thought I would bring in some Basquiat Society. Well, it's the Society's honor to welcome His Honor tonight, Phil Berger. Phil Berger is Associate Justice of the North Carolina Supreme Court. He's been in that seat since early 2021. He has an 8-year term, right? So that brings him to 2029 by my calculations. Congratulations. On the night he was elected, he said, Carolinians have voted against activist judges and for the rule of law. Prior to his current position, he was an administrative law judge at the NC Court of Appeals for 3 years. He is a graduate. He has a BA from UNC-Wilmington and a law degree from Wake Forest University. He was 8 years in private law practice and then became the DA at Rockingham County. So, a really sterling record. We're so happy to have him here. This topic, he and I chatted earlier tonight. I learned something about this phrase I did not know was in the Constitution. But one last story. I had the great pleasure of meeting Phil for the first time about 18 months ago, and I was at a conference that I was speaking at. Now get this, 100 judges and law professors. Oh my God. And we were talking about the connection, the intersection between economics and law. And that's where we met, and I thought to myself, now this is a serious jurist, this is a serious judicial mind out there learning things, going to conferences, contributing, asking questions. We were on many panels together. And this is the kind of judicial activism we need. Welcome, Phil Berger.
Well, thank you, Richard. Richard didn't tell you that the conference was in Destin. So to the extent there was scholarship and knowledge taking place, it was on the beach and at the bar. But no, I want to set my clock so I don't go long. I know we all have important tasks to attend to, but I want to thank Richard, Brad, the Basquiat Society, and all of you for having me this evening and allowing me the opportunity to be here and discuss a topic that I hope you will find interesting. Admittedly, this is not economic theory, and it certainly will not rise to the level of an academic presentation, but I think you'll find it in keeping with the purpose of this group. What I'd like to do today is discuss an interesting clause in the North Carolina Constitution. It is unique and represents a foundational principle for the protection of property rights here in North Carolina. And I'm struggling already. There we go. All right, so our Declaration of Rights begins in Article 1, Section 1. And to the casual observer, and Richard and I talked about this a little bit earlier, you can easily gloss over this phrase and think, well, my goodness, they took this right from the Declaration of Independence. But in North Carolina, the people have enshrined in their Constitution a seemingly innocuous clause that packs quite a bit of punch. The fruits of your own labor clause is not a relic of the old days, but rather it's a strong safeguard that's available to North Carolinians, which serves to protect property interests and economic liberty. Now, the inspiration for this talk this evening is my fellow Justice, Richard Dietz. Justice Dietz and I have worked together for about 7 years on the Court of Appeals and the Supreme Court. And over the course of that time, we frequently have the opportunity to discuss these sort of innocuous clauses, hidden clauses in the Constitution. And he wrote a paper that I would highly recommend to you. It's called Factories of Generic Constitutionalism. Basically, it's about lockstepping the state courts, state constitution with the federal constitution. No daylight between the two, essentially. That some judges interpret the clauses in the state constitution as being synonymous or coextensive of the federal constitution. And he discusses in this paper the danger of doing that because there are clauses in the North Carolina Constitution, like the fruits of your own labor clause, the monopolies clause, the emoluments clause, that have very specific meanings for protections of property rights and liberty interests here in our state. So it's my hope this evening that in our discussion, this topic, at least on my part, leads to some type of published article. Fruits of your own labor clause is something I'm very interested in and have written about in opinions, and we'll get to that in a bit. But I hope it sparks your interest as well as an area that is deserving of scholarship and deserving of your time, especially by those liberty-minded individuals in our state. I am also grateful this evening that my friend, former Chief Justice Mark Martin, has joined us this evening. Chief Justice Martin is now Dean at the High Point University Law School, and he is the true expert on the Constitution here this evening. So any questions I get over the course of the presentation, I'm going to direct to him. All right, so a roadmap, if you will, or from the 1890s, a railroad map of North Carolina. We are going to discuss a little bit about what is the fruits of your own labor clause, what are the possible historical sources of this clause, and how has the Supreme Court applied and interpreted this clause to protect economic liberty here in this state. Ultimately, my goal tonight is to demonstrate that the fruits of your own labor clause is an actionable provision that has been and will continue to be a valuable tool that offers robust protections for your rights here in this state. All right, ground rules for you baseball fans. The Code of Judicial Conduct prevents me from commenting on cases that are currently pending or may likely come to my attention on the bench. So there are some things that I will not be able to comment on. There are some questions that you ask that I will not be able to answer. I will sound like a politician, right? I just can't answer that, but there's a good reason for it. This talk tonight is intended to be, did I lose it? That's okay. This talk tonight is intended to be more of a historical and educational presentation, and again, not in any way to be construed as a discussion of any pending matters. All right, so historical uses of the clause. Well, around 450 BC, Solomon says in the book of Ecclesiastes, now interesting fact about Solomon, after he built the temple in Jerusalem, he took his son Indiana Jones to find the Holy Grail. it is odd that Solomon looked just like Sean Connery. And how they know, who knows? But Solomon in Ecclesiastes says, you know, I know there is no good in the trials of this world, and man's purpose is to rejoice and to do good in his life. And also that every man should eat and drink and enjoy the good of all his labor. It is a gift from God. Right? So here we see that Solomon understood that the enjoyment of the fruits of your labor is a gift from the Creator, and the purpose of life is to rejoice and to do good with the tools of production that have been given to us. Aristotle also provides an example from the 4th century BC in his book Politics. He writes, "For men must be able to live, and live well too. Accordingly, the art of acquiring property has been introduced to provide for livelihood. And as in the arts, which have a definite sphere, the workers are more truly workers when they apply themselves to that which is their own than when they apply themselves to that which is not their own." So I submit to you that Aristotle understood that humans are more productive when there are incentives, an economic term for an economic group, right? And one of the greatest incentives that we can have is ownership and improvement in our own property, right? The development of the fruits of our own labor. Adam Smith, somebody that I know this group is very familiar with, right, said that the real price of everything, what everything really costs to the man who wants to acquire it, is the toil and trouble of acquiring it. What everything is really worth to the man who has acquired it and who wants to dispose of it or change it for something else is the toil and trouble which it can save to himself and which it can impose upon other people. So our founding fathers, who were certainly familiar with the Bible, certainly familiar with Aristotle, and definitely familiar with the writings of Adam Smith, also took on this flavor of the fruits of your own labor. James Madison in Federalist 10, which is published around 1787, argues that production is a property right, and protection of that right is a function of government. He said, "The diversity in the faculties of men from which the rights of property originate is not less an insuperable obstacle to a uniformity of interest. The protection of these faculties is the first object of government." Alexander Hamilton in Federalist 70. Now, you will not see a picture of Hamilton here because he is one of the biggest scoundrels in the history of our country. So I will not dignify him with a picture. Said that basically the attentive merchant, the laborious husbandsman, the active mechanic, and the industrious manufacturer, all of these types of men are eager in the expectation and the growth of their labor. Jefferson went on to say in one of his famous writings, and this is dealing with some of the economic protectionism of Great Britain, "We take leave to mention to His Majesty certain other acts of British Parliament by which they would prohibit us from manufacturing for our own use articles that we raise on our own lands with our own labor. By an act, an American is subject to make a hat for himself of the fur which he has taken, perhaps on his own soil, an instance of despotism to which no parallel can be produced in the most arbitrary ages of British history. By another act, iron which we make, we are forbidden to manufacture. And heavy as that article is, and necessary in every branch of husbandry, besides commission and insurance, we are to pay freight for it to Great Britain and freight back again for the purpose of supporting not men, but machines in the island of Great Britain." So Jefferson here is referring to the fact that anything that Americans at that time acquired on their own, whether it was by hunting on their own property or digging for materials and metals on their own property, had to be shipped to Great Britain, not for any purpose to serve the fruits of their own labor, but to help British citizens in the production and economic interest in the homeland. So Jefferson, our founders, and a large swath of the American colonists at the time were very familiar with the way that government used the law to prohibit free competition to the benefit of insiders who had political control over the state. Colonial crony capitalism, right? And that, as our founders knew, was a threat to economic liberty. Now, when we think of the fruits of our own labor, we think of apples, and we think of John Locke. This gentleman certainly comes to mind, right? Second treatise on government, Locke argues that individuals have a natural right to the fruits of their own labor. He wrote that though the earth and all inferior creatures be common to all men, yet every man has a property in his own person. This nobody has any right to but himself. As Richard and I were talking before, property in his own person. The labor of his body and the works of his hands, we may say, are properly his. Whatever then he removes out of the state of nature, the fur, right, the minerals from the ground, whatever he removes from the state of nature and what nature has provided and left in it, he has mixed with his labor and joined it to something that is his own, and thereby makes it his property. So the Lockean theory of property rights asserts that individuals have a natural right to acquire, use, and dispose of property as they see fit, so long as they do not harm others in the process. And he maintained that when an individual mixes his labor with previously unowned resources, he thereby acquires a property right in that object or item. So Locke used several examples to illustrate his theory of property rights. One of the most famous is that of the apple orchard, right? So Locke proposed the following scenario. A man walks into a previously unowned apple orchard and begins picking apples. By picking the apples, the man has mixed his labor with the land and thereby made this his own property. Locke argues that this is just a way of acquiring property because a man is not harming anyone else in the process. He also used an example of hunting similar to what we've discussed earlier. Overall, though, Locke's examples illustrate his belief that property rights are rooted in the idea of individuals using their own labor to transform resources into valuable property. This simple idea had a significant impact on the development of liberal political philosophy and the concept of property rights in Western legal tradition. His ideas were influential in the writings of the Enlightenment thinkers and were influential in the American Revolution and the drafting of the Constitution of the United States. Now, because we are at the Bastiat Society, we will briefly talk about Frederick Bastiat and the law. I have two former interns here, two ladies who will be clerks with me here in a year. And they can tell you that my summer interns are required to read the law by Frederick Bastiat when they come to work with us. So as you know, Bastiat wrote Life, Faculties, Production. In other words, individuality, liberty, property. This is a man. And in spite of the cunning and artful political leaders, these three gifts from God precede all human legislation and are superior to it. We are endowed, according to Bastiat, by our Creator, with the means of production or labor. So Locke's theory of property and Bastiat's idea of production share many similarities. Both Locke and Bastiat believe that property rights are natural rights that are derived from an individual's labor or production, and that individuals have a right that pre-exists government to enjoy the fruits of their own labor. Locke's theory emphasized individual right to labor and the resulting ownership of the fruits of your labor. Bastiat, on the other hand, emphasized the importance of production and creating wealth and prosperity. In essence, both Locke and Bastiat conveyed that individuals have the right to create and own property that results from their labor or production. And these rights and protection of those rights by government is essential to individual liberty and prosperity. Now, here is the hero in our story this evening. Forgive me as I check the clock. So to the left in this photo is Albion Tourget. Now, many of you have probably never heard of Albion Tourget. And unless you're a legal scholar in North Carolina, I don't claim to be, but even many legal scholars don't know the name or the product. So Tourget here is pictured on the left. He was a Confederate soldier, he was a Union soldier from Ohio, was injured and wounded at least twice, maybe 3 times during the course of the Civil War. Like many Northerners, he moved south, settling in Greensboro, where he practiced law. I don't believe the town of Cary had been incorporated yet, otherwise he would have certainly landed here. He was a prominent lawyer, judge, writer, and fought for the rights of newly freed slaves and blacks and laborers of the late 19th century. He later was one of the lawyers in the separate but equal case of Plessy versus Ferguson, fighting for the rights of, as I mentioned, Southern blacks. He was frequently a target of threats from the Ku Klux Klan, and I believe one of his colleagues was actually killed by the Klan in an incident that occurred here in North Carolina. Again, I will reference Justice Dietz and his note on factories of generic constitutionalism. Dietz notes that Tourget said, the slave was a man forcibly deprived of his natural and inherent right, the right of self-control, of life, liberty, and the pursuit of happiness, not from any desert on his part, not because of any infraction of the laws of society, but simply because another man desired the fruits of his own labor. In another book, Tourget wrote, we determined to strike a blow at the root of evil, and this is dealing with the 1868 Constitution, to secure to every man the fruits of his own labor, and the right to dispose of it as he pleased, without let or hindrance from any other man, any law, or any custom. Right? So there's definitely a thread that runs through Tourget's writings leading up to and involving the 1868 Constitution, where the fruits of your own labor clause is found. Clearly, Tourget was using the phrase. The problem we have is we have no information, we have no writing, we have no historical evidence that when Tourget penned the phrase in his books, in his writings, that he connected them back to Locke. Right? So there's a bit of a gap. There are breadcrumbs, right? There are all these indications. He certainly was aware of Jefferson's writing. He certainly was aware of Locke's writings, probably even Bastiat at the time. But there's nothing that we can connect Tourget to the fruits of your own labor clause historically, but certainly included in our 1868 Constitution. And again, here is the wording. And it's interesting, right? It's not that you're entitled, as Richard commented before we began, it's not that you're entitled to just the fruits of your own labor. You're entitled to the enjoyment of your fruits to the fruits of your own labor, right? So what does that clause mean? What do we glean from the inclusion of this provision in our state's Constitution in 1868? So we're going to turn our attention now to interpretation and application by the Supreme Court. Specifically, we're going to look at cases that focus on the application of this clause and perhaps the application and meaning of fruits of your own labor. So we're going to start with what I call pre-fruits cases. And yeah, I know it's kind of hokey, but so in our pre-fruits cases, there's certainly a prior indication from the courts that they certainly understood that there are property rights that cannot be divested. Now, we're not talking about interference or divestiture by government. We're talking about in relation to other people. So the first case where this phrase appears is Baker versus Carson in the early 1800s. Essentially, what you have here is plaintiff has a parcel of land, defendant has a life estate in that land, and the plaintiff has basically been promised, look, I'm going to convey this property back to you by the defendant, and the plaintiff starts making improvements upon the property. And the defendant, I'm not saying, plaintiff is a male, defendant is a female, might explain some of the language here, right? But the plaintiff has made these improvements and is essentially out his improvements now because the defendant will not convey the interest in the property. And the court said the defendant here sought to have her interest in the parcel reinstituted to her, and the court determined that the plaintiff was entitled to be compensated for his labor because she fraudulently took the profits, right? So the compensation here is labor, and the court in this last little portion of this excerpt says, this is a doctrine which seems to be, if we were to grant the defendant her interest in full, that's a doctrine that seems to be subversive of first principles, right? So the court here says, we're not going to sanction this type of deprivation of a right, not constitutional, but deprivation of a fundamental property interest. Similar situation in Alvea versus Griffin. You have a property dispute where there are improvements made, and the interesting thing here is the court says you're not just entitled to the profits or the labor, the compensation for the labor you expended, but here, if the defendant does not follow through with the conveyance back to the plaintiff as promised, the plaintiff must be compensated for the increase in value based on the improvement to land, right? So you have a first case where you say you're going to have to pay for the labor, and now it's not just labor, it's an improvement, right? The value of the improvement on the land. But again, these deal, all right, so this is really corny. Those cases and others deal with sort of this private nature, and there are some fruits cases that come along later in the early 19th century, early 20th century, that basically deal with contractual rights and impairment of contracts, covenants not to compete. And again, the court is very jealously guarding these sorts of individual property rights and your right to work, and that will come into play a little bit later. But again, I think this early history shows a commitment by our courts to individual liberty and your right to work. Now, the phrase first gets used in a significant fashion, I would submit, in a concurrence by Justice Douglas. Justice Douglas is an interesting historical figure in his own right, but I just want to make this point. Why would you write a concurrence? Right, so what's the point of a judge or justice writing concurrence? One is to clarify perhaps a position that the judge thinks may not be so crystal clear in the majority opinion. The other would be to expand on the law a little bit. I believe the law is here, but maybe could be a little bit further than what the majority thinks. And then to express a personal view, perhaps. So those are sort of the three main reasons you would write separately. And in the case of Wilson versus Jordan, the legislature had created new criminal courts out in the western part of the state. And then a subsequent legislature, and this gets into some interesting historical wrangling with some of the justices, but another legislature comes in and says, well, no, we're going to repeal that statute. So there's a dispute with the clerk. I should be paid, I should be compensated, I should still have my job, those sorts of things, right? And there's a huge discussion by Justice Douglas in his concurrence about separation of powers, right? And in that separation of powers, Justice Douglas references the Declaration of Rights, and he discusses the phrase that's up on the screen, but he also says, the power in our government resides in the people, and the fundamental rights protected by the Constitution and the Declaration of Rights are broad in scope, right? So this doesn't deal necessarily with property rights, but it deals with how do we interpret Article 1, Section 1. And Justice Douglas, I submit, says, you know, these are pretty broad protections that our founders in the 1868 Constitution, 1776 Constitution put into our founding document. Okay, so a year later, again, you see this is Justice Douglas concurring. Fascinating case. I commend you and suggest that you all read this case. State versus Hay. Mr. Hay is a resident of, oh my goodness, somewhere out west, right? And the legislature had given localities, municipalities, the authority to compel vaccination against smallpox, okay? And the court says, no, the legislature has the authority to do that. And Justice Douglas, in his separate opinion, says, well, there's got to be a limit, right? these protections in Article 1, Section 1, specifically the fruits of your own labor clause, extremely broad, right? But you cannot tell me, paraphrasing, you cannot tell me that if a vaccination was dangerous to life or limb, that the government could be allowed to compel someone to take the vaccination, right? And so again, there are these limits, but we're introduced in this case to the concept of police powers, right? So you have your rights under Article Section 1, Article 1, Section 1, Declaration of Rights, right? But there may be some friction with the police powers of the state. And so the court spends a good bit of time over the next several years at balancing out that friction, and that's where we will go next. All right, and essentially, police powers involve health, safety, welfare, and morals. Right? So the ability to regulate alcohol in some way, shape, or fashion. Burke County is given the authority to regulate the manufacture, sell, and disposition of liquor for gain. Right? Well, Mr. Williams comes rolling through Burke County, and he's got half a gallon of liquor in his car, gets stopped, and the police are like, "Oh my goodness, Mr. Williams, you know, this is a problem for you. We're going to have to confiscate your liquor, and we're going to cite you for a violation of the statute." And Mr. Williams' attorney moves to quash the indictment under the fruits of your own labor clause, right? Said, I have a right to my property. Again, an actionable, this is not some underlying clause in our Constitution. This is an actionable portion. All right, so the court says, no, you know, there is this thing, police powers, health, safety, welfare, morals. And the court goes on to reinforce this idea that Justice Douglas had, that there are limits, though, right? The police power is there, but we've got these rights that are broad in scope. And the court sides with Mr. Williams and says, look, there are any number of reasons somebody could bring alcohol into a county. Selling it may be one of them, but it ain't the only one, right? You could be doing any number of things with this alcohol, and we're not going to hold you criminally responsible. And the court goes on to say there must be a real and substantial relation to the evil the legislation seeks to address, but it cannot palpably invade a fundamental right. All right, so that sounds like a pretty strong protection of our rights of the right to the fruits of our own labor, right? Cannot palpably invade. Well, then we get to the case of State versus Lawrence. And the State versus Lawrence case is one of these early economic liberty cases that our court wrestled with, and it had to do with regulation of the photography industry, right? So who knew there was a photography board here in North Carolina at one point? So the argument essentially was, look, all of these, now we're not talking cameras like we have today, right? These are the ones with the flash that goes off and the explosion, right? So the argument is basically there are chemicals, there are all these combustibles, there are fire hazards. We need to make sure that the people taking these pictures know what they're doing, right? And the court says, well, you know, even in our day, even back in 1938, people are using photographs in court to show us accidents and crime scenes and reconstructions and all. They're used for evidence back then. They use it for advertising. Sort of photography is a general use, right? And then the court goes on to discuss police powers a little bit, but the state concludes, you know, the state can require certification for businesses and can require examination for competency. And it's really a legislative question as to what the policy ought to be on who gets regulated and how. And then you see this interesting sort of question in a dissent, again, why do you write separate opinions, saying that, well, what is the limit of the legislation? Again, this friction, right? There's a friction in this clause. And
Justice Berger?
yes, I've got 5 minutes. Oh my gosh. Okay. All right. So quick. Clearly, my clock is not working. All right. So that's Lawrence. We get to Harris, which is dry cleaners. Right. There's a dry cleaning board, and the court says, look, we've had enough of this. Somewhere in between regulating professional industry and these sort of ordinary trades, there's a thread, and the closer you get to these ordinary trades, the thread gets thinner and thinner, right? And we're going to protect economic liberty and property rights in that sphere as you get closer to the trades. Barber, we had a barber's board that was really a cartel, economic term, so that was very interesting. All right, then you get to one of the seminal cases in North Carolina for a number of reasons, and it's State versus Balance. And State versus Balance it essentially goes back to State versus Lawrence, a photography case, and says, look, we got it wrong, okay? And there's a huge discussion about stare decisis. Why do we deviate from prior precedent, right? And then a discussion about what really is economic liberty under the fruits of your own labor clause. And again, not to, court basically sets up a 3-part test, and part of that test moves into some of this palpably invades your property rights to, it doesn't get this far yet, but is there a rational basis for the regulation? All right, so a big case in terms of protection, but we're sliding into rational basis, which is where the government can basically go, any reason sort of makes sense to us. There's a tile manufacturer and laying board, which again, who knew? This case gets into deprivation of property rights in a different sphere. All right, then we get to State versus Warren, regulation of real estate agents, right? Who knew that Georgia had such a big deal with haunted houses, but I found the slide and they did. But Warren has this phrase here: arbitrary interference with private business and unnecessary restrictions. Right? So it is not in North Carolina, according to Warren, just taking of property. It is interference by government with the fruits of your labor. Right? It is unnecessary restrictions upon the use of your property. Right? So again, getting back to Justice Douglas, broad in scope, right? Warren says, yeah, it's potentially really broad if we're talking about interference. Let me do 2 quick cases. All right, there's more and more and more. All right, so moving forward. All right, my favorite justice, me. There are 2 dissents I want to tell you about real quick. First is Harris Teeter. Did you guys work on Harris Teeter? No. So Harris Teeter, Mecklenburg County is imposing a tax on old business equipment from Harris Teeter. Right, so if you were to put the items on fair market on eBay, you get X. The county said, well, we're not going to use fair market value. We're using X plus $8 million. Okay, so this difference in valuation costs them potentially $8 million towards their taxes. And I said in there, look, any business that earns a rate of return, and that comes from majority opinion, which is above industry norms, right? Risks the government effectuating an extra statutory taking, something they're not supposed to do, and it's possibly a violation of the fruits of your own labor clause. And then the other one deals with developer, right? So just sort of assume we've got development here in this portion of the county. You've got a hook on to our water sewer to benefit this area of the county, all right? And so in this, some justice wrote, it may not be rational basis, it may be increased scrutiny such that this taking for this property has to have direct proportionality. So that is a very quick summarization and overview of the fruits of your own labor clause, and I'm happy to answer any questions that you may have.
petition or whatever it is, in this state, when I come to North Carolina, I gotta get a re-license. So I'm curious on that. And then state was saying there's a really bad hump in this back, so I couldn't hear. What was the outcome of that? It sounds like there was a mandate about vaccines, which it seems like it was relevant recently. How did that turn out? I didn't hear what you said in that particular case.
Yeah, so in Hayes, the court, Chief Justice Clark wrote that the vaccination was permissible. The compelled vaccination was permissible. But again, Douglas writes, hey, there's got to be a limit on some of this. So again, I would commend that to you. It is a fascinating case because of how relevant it is potentially. As to the first, why are there not more cases or information? And I would just submit that it's because that litigation hasn't made its way to us, and I can't comment other than
I thought you might answer that on at least one of the two questions.
Yeah. Yes, sir.
It seems that eminent domain policy would be like a direct contradiction to this. Like there seems to be like a public good argument that the state often makes to claim private property, especially businesses, in order to, do something for the common good, whether you build a sidewalk or whatever. How does that play into this topic?
Yeah, so this it kind of starts with this Greensboro case in terms of the taking for public use, and we have I apologize. We have a case that's coming through the system now dealing with this issue, and I believe it was pled on the fruits of your own labor clause. So it will that issue has been addressed and is making its way through. Yes.
So just thinking about how our economy is increasingly dematerialized, so the fruits of our labor might look vastly different 20 years from now, even because of the digital economy that's at play here. So what do you think Locke would say when we're talking about private property rights in the context of just websites and e-businesses?
Now, so just generally, I think he would say anything that you put your mind to, right? And you produce on your own. And this is a huge issue with AI. How many of you knew that there is one of the top podcasts in the country right now is AI Joe Rogan, where AI Joe Rogan interviews individuals who are not on his show, and it's right. So these issues are out there and going to be litigated in the near future. If you have put your labor into an in-person show, and someone takes that product and does something else with your labor, what does that mean? Now, as far as government interference, I think the way I would answer it is a little bit differently. I would say, think to the debate around the First Amendment, right? And all of these video games, right? We've got to outlaw video games or rap music or this music with these types of lyrics or whatever, right? Well, there's no parallel back in 1776 or 1791, right? But they certainly had Grimm's fairy tales, right? Which, if you read those, oh my goodness, some of the scariest things you will ever see would frighten a child, right? But that's protected speech. And so I think while there's maybe not a direct connection, there are corollaries where our founding fathers, whether it be under the federal constitution or the state constitution, would certainly understand that the production and manufacture and labor that goes into bringing what's in my head to the public are protected. Yes?
Seems to me that the fruits of your labor clause ought to put a big crimp in restrictive zoning laws. Has that been the case?
Has that been the case? Again, I would get back to the point I made with Mr. Hicks, which is I don't, as you can see, these are basically all of the cases involving the fruits of your own labor clause. There are a couple others out there, but this is the body of law. So I would just submit there's probably not enough litigation that's made its way through the court system for us to have a good answer on that.
So you talked a little about the level of scrutiny, the rational basis that's used for a lot of this litigation, and you mentioned that you had contended in that dissent that perhaps a higher level of scrutiny is required. Can you explain a little bit about that and why you believe a higher level of scrutiny might
Well, think back to where we started, right? We have rights that are broad in scope, right? And so if you have a right that's enshrined in the Constitution, then how does a statute interact with that, right? Where is the friction? And we know that police powers, general good, sort of rub up against that, but what level of scrutiny should the violation of a constitutional right be afforded? And some of the cases early on said, that's you've got to overcome a pretty good bar before we're going to sanction this government activity. But slowly and slowly it moved to rational basis. And this gets back to the concept we mentioned at the beginning of lockstepping, right? We have looked at some of the federal case law, and it has sort of morphed into this singular rational basis. Well, is that what our founders intended? Is that when Tourget is talking about freeing slaves, right, Southern blacks and their ability to overcome some of the hurdles and obstacles that were placed in front of them, did he think those actions should get rational basis? Now, there's no answer to that, but what is the thought, right? So there is no solid answer in our case law, other than it has morphed to rational basis, if that makes sense. Yes.
The Christopher Liquor Laws, which of the three versions of our state constitution would that most appear?
Right, so good question. There are three versions of our state constitution: 1776, 1868, the Reconstruction Constitution, and then 1971. It first appeared in the 1868 Constitution. Now, one of the interesting things is our first Constitution, 1776, predates the Bill of Rights and the U.S. Constitution, right? So when we interpret the federal Constitution, where do we turn? Right, we look at the Federalist Papers, the notes in the convention, and certainly there's a wealth of information there. But I submit that when we're doing some of that interpretation, we ought to look to the state constitutions, right? Because the state constitutions, although bringing them into being a little bit different, a little bit easier perhaps than the federal constitution, but the state constitution offers such robust protections that there's a corollary, not directly related, but there is a corollary. But it first appeared in the 1868 Constitution.
So are you saying that the fruit of your labor clause that's in the North Carolina Constitution is a kind of special bulwark against the expansive role of government? And does North Carolina have a kind of secret weapon, if you like, against that, against burdensome taxation, burdensome role of government?
So is it a secret weapon? I would say no. Is it something that could be explored more, whether it's by literature, scholarship, or litigation? Absolutely. And I would commend to you this case, both the majority opinion and my dissent, for a discussion about the interaction of perhaps arbitrary taxation and the fruits of your labor clause. This is just a quick snippet of the case, but this case really deals with an action by government that was contrary to fair market value. The government essentially admitted that they used this higher valuation to extract more wealth, right? And the majority said no, that's permissible. But this dissent says, there is a limit. It doesn't say where the limit is, but it says there's a limit.
Am I allowed to ask another one?
Yes.
I'm also curious about, you said the limit. You're entitled to the fruit of your own labor, and your labor is whatever you're producing. It's not just your applicable, it's a man's money, right? So it's the fruit of the income that I receive is fruit. But then government taxes me. Is that then defining me as the fruit of my labor, or am I taking this as well?
I would say, our Constitution and the laws passed by the legislature certainly authorize taxation, right? This case.
I'm not proposing that I do the Wesley Science Plan.
But so this case at the very least suggests that there, even though you have this, the government has the right of taxation, that there has to be some limit. And there's some other clauses that come into, we have a uniformity clause and some other things, but I would commend this case to you as one if you're interested in at least two justices' opinion of taxation as it relates to this case. The dissent may provide an answer. Yes, sir.
I have not heard of this before, so I commend you for having brought it to our attention. It's an interesting, I guess it is a secret weapon. It's been a secret to a lot of us. It's great that you have brought it to public attention. It strikes me that this might have implications, and I wondered if anyone has tested it for regulatory takings. So, for example, in the state of Rhode Island, a garbage man named Palazzolo bought a bunch of undeveloped wetlands and then said he was going to build hotels. And the EPA said, no, you can't do that, that's wetlands. He said, well, you're taking the value of my land. The regulation is substantially reducing the value of my land. Now, in that case, that was kind of dumb because the wetlands were really cheap because it was clear you couldn't do that. But under many circumstances, if you impose a regulation after the fact, I have a reasonable expectation to the enjoyment of the fruits of my labors. And the regulation doesn't take away my property, so I'm not actually eligible under the Fifth Amendment. Might I be eligible to some compensation for the regulatory taking, which takes part of the value of my land?
So I would say I have to be careful answering this. I would just point you to.
My question actually was, has there been, this is a question of fact, has there been litigation that has tested the idea of regulatory taking under your theory?
No, there has not. But there is language in the cases that suggest, well, I say no. There is the one Greensboro case that deals somewhat with that. But I would say that there's the language from the case that says interference with a property interest is potentially a deprivation under the Fruits Clause. Now the problem you have is the Fruits Clause applies only to action in North Carolina by the North Carolina government. So as it relates to federal agencies.
Well, and as you may know, the state of Oregon actually passed a statute about regulatory takings about 10 years ago. And it was done by popular vote. It wasn't an act of the legislature, but they passed it as a ballot provision. And it required the state to pay partial takings. And it was repealed within the year because the difficulty of, there's the tsunami of litigation as a result bogged the courts down because there was been estimated that we commit 3 felonies a day. The amount of things that take some portion of our value, we couldn't possibly successfully litigate. So the attempt that I know of to try to instantiate that theory crashed and burned because it's impossible to litigate it. So I'm fascinated by what sort of balance there might be if you were able to enable something like a regulatory takings doctrine.
Yeah, and so I agree with you. There has to be some balance between the floodgates of litigation and let justice be done though the heavens fall, right?
Well, if we have no more questions, thank you very much, Justice Berger. Sorry about the microphone situation. I'm not sure what happened there. Thank you very much, everyone, for coming. I can tell just it's really a nice synergy of volunteer effort. Everybody's had at least one chance, I think, to put up the backdrop, which is great. Thank you very much, Craig. And please do, when you come, feel free to write your name on a name tag so we can get to know you better. Really appreciate those people who made contributions to when they register, because it really takes the bite out of some of the expenses that we have here, and I think we're doing pretty great. Really excited about the speakers that we have coming up. We have who's from John Locke Foundation, Donna King, next month. We may be having a joint session with John Locke in July, which is a little different for us because we normally are dark in July, but we might do a little special thing here. In September, we're kind of open, but October, we're going to have our illustrious Michael Munger. And in November, and he'll be talking about the ABC Commission, which is awesome because, I mean, like, I've always wondered, being from California, what in the world? Like, why do you have to go to this special place to get a beer? No, it's not a beer, but anyway. And then in November, we're having a really cool presentation by Jen LaGreca from the Wing Victory Foundation, and she's going to be talking about her book, which is really a novel, a really cool novel, and it talks about, interestingly enough, the situation where there's a national election commission that sort of rigs an election. It was kind of recalling some of the issues we might have seen a few years ago. Anyway, I really look forward to that. Thank you very much for coming. Have a wonderful Wednesday, and we'll see you next time.
Yeah, I'm going to speak to him too, just to say, I didn't know. I had a case where I had a clause, a similar one, but in a different way. Was it that same clause? No. I mean, I participated in, you saw the one, 2008, analysis on that. Yeah. The two Justice Berger law clerks. Hey!